They cut down my grandfather's memorial tree, but I took them to court and found the smoking gun. The HOA called it a beautification initiative. That's how they sold it at the meeting. They had slides, a little presentation, words like uniformity, sightlines, and modernizing the landscape. The goal, they said, was to remove the tall, older trees from the neighborhood's shared and bordering areas and replace them with smaller ornamental species that were easier to maintain and gave the community a cleaner aesthetic. Most people agreed the trees were big. They dropped leaves. They needed trimming. The HOA promised to handle removal at no upfront cost. If homeowners signed a compliance form, a lot of folks did. Some even seemed excited about it. I didn't sign. The tree in my yard wasn't just landscaping. It was planted by my great-grandfather in 1946, when his son, my grandfather's older brother, never came home from World War II. The story had been passed down in our family, like something fragile. He planted that oak sapling himself, right where it still stood, because he wanted something living to mark the place in time when everything changed. We had photos of it when it was barely taller than a fence post. By the time I inherited the house, it towered over the property, strong, healthy, a little crooked from decades of wind, but still standing. So when the HOA asked me to voluntarily participate, I told them no. They asked again. I told them again. They said the tree disrupted their design plan. I explained its history. They said exceptions were difficult. That's when I started to get suspicious. I'd dealt with HOAs long enough to know that when they start talking about consistency, they sometimes mean, we'll deal with you later. So I made a call to the County Historic Registry office. Turns out, you can register a tree as a memorial landmark if you have documentation and historical significance. It took paperwork, photographs, affidavits from relatives, but within a few weeks, the tree was officially recorded as a protected memorial planting. I sent a copy of that documentation to the HOA. They didn't respond. Months passed. The rest of the neighborhood changed. Trees came down. Crews moved through like a slow wave of chainsaws and wood chippers. My oak stood alone by comparison, but that didn't bother me. Then I went on vacation. 10 days, that's all it took. I came home to an empty space, not a trimmed tree, not a damaged tree, gone. Cut flush to the ground and the stump ground out. So aggressively it left a crater where the roots had been. My lawn was torn apart by heavy equipment. Ruts from machinery tracked across the yard like scars. For a long time I just stood there. There's a strange kind of silence when something that's been there your whole life suddenly isn't, like your brain keeps expecting to see it and hasn't caught up yet. Then I saw the invoice taped to my front door. Tree removal services rendered. They billed me, along with a fine for failure to maintain lawn condition. I called the HOA immediately. They said the removal had been part of the project and that my refusal had been noted but overridden for the good of the community. I asked if they understood they had cut down a registered memorial tree. There was a pause. Then they said they'd look into it. That's when I called a lawyer. The case moved faster than anyone expected, mostly because the facts were not complicated. The tree was documented, protected. The HOA had been notified, and they cut it down anyway. I took them to court. At first, the HOA acted like this was just another homeowner dispute. Their attorney talked about miscommunication, project scope, and landscape continuity, using the kind of language that sounds reasonable if you ignore what actually happened. They assumed it would be settled quickly. They assumed wrong. My attorney requested discovery, every document, communication, and internal discussion related to the tree removal project. Contracts, meeting minutes, approval chains, vendor correspondence. The HOA produced what they claimed was a complete record. It wasn't, at first glance. Their paperwork looked clean. Too clean. Meeting minutes summarized decisions without detail. Emails referenced attachments that weren't included. Approval forms appeared to skip steps. My attorney noticed the gaps immediately. You don't accidentally forget this many things, he said. So he requested the contractor's records too. That's where the thread started to unravel. The tree removal company, unlike the HOA, hadn't tried to sanitize anything. Their project manager had saved everything: emails, flagged site notes, internal questions about whether the property should even be touched. One message stood out. Subject: Lot 47, Memorial Tree. County Registry shows protected designation. Do we have written clearance before proceeding? Recommend holding work until confirmed. That email had been sent directly to the HOA, liaison overseeing the project, the board member, whose brother-in-law owned the company. The response came less than an hour later. We are aware. Proceed as scheduled. HOA authority covers this. There was no county clearance, no legal verification, just that sentence. They cut down my memorial tree. But I had the smoking gun. That was the moment the case stopped. Being about negligence and became about deliberate action, the judge addressed the board directly. You didn't overlook the protection, he said. You acknowledged it. You understood it. And then you chose to ignore it. No one answered. The ruling was issued from the bench. The HOA was found liable for unauthorized removal of a protected memorial tree, trespass, property damage, and bad faith conduct during litigation for failing to produce complete discovery. The attempt to conceal the email chain was specifically cited as aggravating behavior. Damages were awarded accordingly. The HOA was ordered to pay for restoration of the property, legal fees, and additional compensation tied to the destruction of the registered memorial. The board member who pushed the removal resigned. Before the written judgment was finalized, outside the courthouse, the HOA's attorney declined to comment. They didn't hold another beautification initiative, and they now read every registry record very, very carefully.